So good morning and welcome to the Business and Human Rights session at the Future of Peace Leadership Rotary Peace Symposium, April 22nd in 2021. My name is Jonathan Coleb. I'm the Peace and Conflict Theme Leader at RMIT University's new Business and Human Rights Centre. Let me begin by acknowledging that I'm joining this session from Melbourne and wanted to respectfully acknowledge that I join you from the unceded lands of the Boonwurrung people of the Kulin Nation, the first peoples of this land I'm on, who've been here for thousands upon thousands of years, and pay my respects to their elders past, present, and future. Let me also acknowledge and congratulate Rotary Australia on their 100th birthday. This is part of the centenary celebrations, so happy birthday and to many more. This morning, we're going to continue our conversations around peace leadership by discussing a really topical issue, business and human rights. Thank you all for coming. By way of introduction, all human beings are born free and equal in dignity and rights. So starts the Universal Declaration of Human Rights of 1948, the seminal document when it comes to human rights. It says that the inherent dignity and the equality and inalienable rights of all members of the human family is the foundation of freedom, justice, and peace in the world. So right from the outset, at the start of the modern human rights movement in the 1940s, there was an inextricable link between human rights and peace. But what does business have to do with human rights? Governments, we know, protect human rights, but businesses? Bhopal, Union Carbide disaster, the Jukan Gorge, Bougainville, Xinjiang, Myanmar, Congo, conflict diamonds. These are all words and events that now instantly trigger and are forever linked with alleged human rights abuses committed by businesses. Should a company respect human rights? What should the consequences be if a company fails to uphold the human rights of their employees or the communities in which they operate? This panel, 4 incredible Australian voices on business and human rights, will help to try and answer some of those thorny questions. I welcome your input too, those of you in the audience. So if you have any questions to put to the panelists, please use the Q&A box down the bottom of your Zoom screen. It says Q&A. It'll pop up a dialog box and you can type your questions there. We will monitor that and I will facilitate the conversation and throw your questions to the panelists. If you have someone specific in mind that you are addressing your question to, please state that in your question. So without further ado, let me introduce the amazing panelists that we have. We have an academic, an advocate, an advisor, and an industry association leader. I tried all A's, all round, all A's. So in the interest of time, I'll keep these intros brief. Lengthier bios are on the symposium website, and also we're going to throw these people's organizations' websites into the chat box as well. Thank you, Naomi, who's helping us today on the back end. Thank you for doing that. So those are in the chat box, so for further information, you can look there. Karen Adams leads the Human Rights Law Centre's work on business and human rights. She has over 12 years experience as a human rights lawyer, advocate in Australia and internationally, including serving as a solicitor on several high-profile corporate human rights abuse lawsuits in the United Kingdom. As part of her work at the Human Rights Law Centre, she's also facilitated complaints to the Australian Government's Treasury Department over human rights abuses committed by companies as part of the Manus Island Offshore Detention Centre program. And a quick note, I should say, Karen will have to duck out a few minutes early. So if there are any questions specifically for Karen, please throw them up sooner rather than later. Yes, schedules couldn't be helped. So anyway, we thank Karen for making the time to join this session. Shelley Marshall is the Director of the Business and Human Rights Centre at RMIT University. She's Associate Professor in the Graduate School of Business and Law. She's conducted research across Australia, India, and Asia on a range of business and human rights issues, and consults for the International Labour Organization as well. Kylie Porter is the Executive Director of the Global Compact Network Australia. That's the Australian local network of the UN Global Compact, the world's largest corporate social responsibility network. Kylie is a member of Australian Government's Modern Slavery Expert Advisory Group and leads a team of experts across the fields of business and human rights, the transition to a net zero economy, the Sustainable Development Goals, and bribery prevention. Phoebe Winpope is Head of Business and Human Rights at the law firm of Cause Chambers Westgarth. Phoebe advises organisations on assessing and mitigating the impacts of their operations on human rights, and advises on how to incorporate human rights into risk and decision-making frameworks of businesses. She has over 25 years experience in the humanitarian sector, including with the Red Cross, the Humanitarian Advisory Group, and Care Australia. I think there's no question at all, this is a all-star powerhouse panel. So thank you all for joining us. This is a conversation, so please feel free again to chime in as you wish. I'm here to facilitate, hopefully to speak as little as possible. And for audience members, please throw your questions into the Q&A box. Let's kick things off. Shelley, being the academic in the room, could I ask you to provide a historical overview, set the scene for us? What is this business and human rights movement that we speak about, and the history of it?
All right. Well, I hope everyone's willing to stick with me as we can really speed through the history of this movement. So Jonathan's already provided a really neat definition at the start, at the outset of this session, which is that business and human rights, that the movement is concerned with the human rights impact of business. So it's mainly historically been concerned with how to ensure that transnational corporations respect human rights, but not only transnational human rights, but that has been a big focus of it, and also to ensure that companies provide remedy, or that remedy is provided when human rights are breached. It overlaps with the corporate social responsibility movement, but unlike that movement, and this is really important, so the CSR movement has been very business centric. The business and human rights movement has been concerned with ensuring that business adhere to universal human rights, and that those human rights are mandatory. Now, we're not there because, as Jonathan set out in his introduction, states have human rights obligations, but businesses don't. But as we know, the power of transnational corporations often outstrips states, particularly when those states are poor. And it's very difficult to bring business to account when they breach human rights, the human rights of communities and workers, especially when it involves a company that's domiciled in another country. So Jonathan might locate the kind of birth of the business human rights movement in the post-Holocaust, post-Second World War phase, but I'm going to skip some decades and start in the 1970s. So in the early 1970s, revelations about wide-scale, unethical and illegal activities by multinational companies prompted calls for international regulation of corporations. And I think it's really significant for this symposium that much of these revelations focused on the role of business in conflict. So two of the best known incidents in this period, which were really big scandals at the time, were the involvement of ITT and other US companies in the 1973 Chilean coup, and also the bribes paid by Lockheed to Japanese officials to obtain Japanese military contracts, including 500 million yen that was paid to the Japanese Prime Minister. with like great success for Lockheed until it became an international scandal. So in response to this kind of growing public unease about the role of companies in relation to human rights, the United Nations became a natural focus for efforts to strengthen the accountability of business actors. And the UN has remained a focus since that time. And I'm going to kind of run through a number of attempts to get some kind of international standard around the behaviour of transnational corporations and the failures really that have occurred up until now. So the UN Commission on Transnational Corporations was established in 1973 after these big scandals, and there was a resulting draft of a UN Code of Conduct on transnational corporations. And this is really our kind of first draft code. And although it was seen to be quite sound, and there was support from many governments in the global south, it was sidelined and then over time derailed. And richer countries sought to develop an alternative to this draft UN Code of Conduct. And so the OECD guidelines for multinational enterprises are really seen as that effort by richer countries to provide an alternative. And even though the OECD guidelines did incorporate some labour rights at this time, there was no explicit reference to other human rights, but it still kind of became the preferred standard. Yet during the 1980s and 1990s, the size and power of transnational corporations grew exponentially. And that, of course, was the result of the other forces of globalization that occurred at that time in terms of other global regulatory forces. So not a lot happened in the 80s in terms of attempts to gain some kind of treaty or UN code, but at the end of the 1990s, UN Secretary General Kofi Annan launched the UN Global Compact, and that followed a kind of decade of campaigning, particularly around labour rights and controversy, for example, around Nike and other big sportswear companies' labour rights. So the Global Compact lacked a means of enforcing its principles, but as Kylie can tell us, it certainly started a process of transparency and acceptance of accountability by transnational corporations. In the 2000s, growing demands for meaningful curbs on abusive practices prompted efforts again in the United Nations in the Subcommission on the Promotion and Protection of Human Rights, an advisory expert body to what's now known as the Human Rights Council. And this resulted in the drafting of an international instrument based on human rights law to strengthen corporate accountability. So in 2003, after 4 years of discussions and consultations, the subcommission approved and these always have really long names, it approved the norms on the responsibilities of transnational corporations and other business enterprises with regard to human rights. So again, this was really heavily and strongly endorsed by civil society, but the reaction of business was largely hostile, not completely hostile, but largely. And the two main criticisms were, firstly, and this will be really familiar to anybody who's still involved in the business in human rights movement, the first criticism was that the norms failed to distinguish clearly between the human rights obligations and states and responsibilities of companies. And the other one was just quite simply that international human rights law should and could only be directly applicable to states. So a rejection of the notion that that businesses have human rights duties. Despite there being, you know, a huge amount of work, discussion, drafting, consultation on this norms, it was effectively consigned to the same fate as the draft code of conduct for transnational corporations that was worked on in the 1970s. So thus died another attempt at a corporate accountability instrument in the United Nations. And this, my friends, laid the way for John Ruggie. So Professor John Ruggie was Kofi Annan's former chief advisor for strategic planning. He was appointed as the special representative on business and human rights in 2005. And unlike the mandates of other UN special procedures, which normally require lengthy country visits and engagement with directly affected people, consultations in country, missions, and so on, the work of John Ruggie was limited to desk study. And even though that was criticised, we could say that it resulted in some freedoms. So Ruggie quickly made it clear that he regarded the UN Norms project as dead. His team worked tirelessly, and in 2008, they released a report called the Protect, Respect and Remedy, a framework for business and human rights. And this really underlines the approach that we see today to business and human rights. So this established the idea that, first of all, it's states that have the duty to protect against human rights abuses by third parties, including business, through appropriate policies, regulation and adjudication. Companies have the responsibility to respect human rights, which, as we'll talk about, has been defined in essence as involving managing the risk of human rights harm with a view to avoiding it, and that victims require greater access to effective remedies. So the Human Rights Council eventually released the United Nations Guiding Principles on Business Human Rights. These were unanimously endorsed. And this has really kind of set the stage for the current movement, or at least the movement we've had in the last decade. So in my mind, the three big achievements of the Ruggie mandate, given the failures in the past to try to achieve some kind of transnational or UN norm or standard or treaty, were that Ruggie kept the business and human rights debate alive in the UN. It didn't die over that period as it had previously. And in the process, it helped stimulate a really tremendous amount of new research and interest outside of the UN. And I see my own work as part of that kind of growth in interest in corporate accountability and business and human rights that occurred throughout his mandate. There was also acceptance by business that it is responsible for human rights in its operations and supply chains or business relations. And this is a really big step. So for me, as somebody who started as a lawyer before becoming an academic, in the 90s, in negotiations with business, they simply did not accept responsibility. I'm not talking about liability, I'm talking about kind of ethical responsibility here. For human rights within the broader supply chains. And now I think there's just no question that there's acceptance about that. And then a final result is a plethora of legislation in the global north, like the Modern Slavery Act, which is the Australian government's answer to protecting human rights, as well as, of course, a number of domestic laws.
We can circle back to modern slavery. Oh, sorry, Shelley.
Yeah. Let's circle back. So just to finalise, we're now in another period of treaty negotiations in the United Nations. In July 2014, there was the beginning of another attempt to design a legally binding instrument. We've now had 3 drafts of that, which have been debated at the Open End Intergovernmental Working Group. And I, for one, kind of wait and with bated breath to see whether it will result in the same fate as the previous attempts in the United Nations to have something which is more binding and places concrete legal obligations on business to respect human rights, or whether it's going to die like the others.
Thanks, Shelley. Super hard task to sort of sum up a massive multi-decade movement. But I think you did a beautiful job there to lay the groundwork. If I may jump to the contemporary day, Karen, Shelley's mentioned a few historical corporate human rights abuses that really kicked off this push for greater regulation, greater business and human rights attention. Do you see a lot of direct evidence of corporate human rights abuses by companies in your work? And in particular, how big of a problem is this for Australian companies?
Yeah, thanks, Jonathan. And thanks so much, Shelley, for giving that really great comprehensive overview to the history. In fact, some of that was new to me in terms of going back to the origins of it in the 70s. And, I got involved in this work really probably just as John Ruggie's mandate was kicking off. I was working at a firm called Lee Day in London at the time, which specialised in starting to develop litigation against multinationals, mostly for their human rights impacts in the developing world. But that movement and the impetus that John Ruggie's team and the development of the UN Guiding Principles had, I think, can't be understated in terms of its importance. Even though, they've left us still frustratingly with a situation where we're still talking about guidelines rather than a hard law, and I think that's something that we should circle back to later in the discussion, because I think really that's the answer, is that to this is binding rules on corporations. But just to come to the work that we do at the moment, so my work at the Human Rights Law Centre here in Melbourne focuses largely on the overseas impacts of Australian companies and trying to prevent and address serious human rights abuses by Australian companies, particularly in our region. And I think unfortunately, it is a growing problem, in part just because the international footprint of Australian companies is expanding all the time. So in mining and exploration alone, for example, we now have over 800 publicly listed companies operating in over 100 countries internationally. And many of those countries have weak governance mechanisms or endemic corruption or issues with conflict and internal conflict. And so they raise very real human rights risks for companies that are operating there. And some of you may have seen just in this morning's Guardian, for example, there was an article about an Australian-backed company, Access Asia Mining, which is exploring for gold right now, right in the middle of the most violence-racked part of Myanmar. These are the types of companies that our work focuses on. But not only is it companies operating directly in countries overseas that are potentially linked and contributing to human rights harms elsewhere, it's also in relation to companies that are importing and have supply chains in other countries. And, Australian companies source primarily from the Asia-Pacific region, which has, for example, the highest levels of modern slavery internationally. There's an estimated 25 million men, women and children in the Asia-Pacific region working in situations of forced labour where they have no free choice over their working conditions and really at the very most serious form end of labour exploitation. We personally have investigated a number of Australian companies over the last 5 years that have been involved in different types of abuses within our region. And that's included, for example, Australian companies, construction companies operating in Papua New Guinea who have been involved in forced displacement of populations and destruction of people's homes and land grabs. We have been involved in investigating Australian mining companies in the Congo that were involved in conflict and in in contributing to very serious human rights abuses and war crimes in the Congo. We've been involved in investigating Australian companies that are involved in very serious environmental pollution in Indonesia and Brazil, and also in Bougainville. And finally, that's not to mention the Australian companies that were involved in very serious and prolonged arbitrary detention of refugees and asylum seekers, and serious abuses, including assaults and sexual abuse within our own detention centres on Manus Island and Nauru. So there are, I think, very real problems with this, and part of the problem in Australia is that we have very little by way of effective oversight or regulation of companies' activities when they're operating overseas or sourcing from overseas. Now, we're starting to see a little bit of movement in that regard in relation to things like the Modern Slavery Act, which requires some large Australian companies for the first time to report, for example, on what they're doing to address forced labour in their supply chains. But that is that is a law that is without teeth. It doesn't have any penalties for companies that don't comply and don't report. And it doesn't require companies to do anything. It merely requires them to report on their existing practices. So even though I would agree very much with what Shelley said, that I think there's very much a growing awareness in Australia among businesses about their responsibilities in terms of human rights, that's not to say that the abuses are still not occurring, and we need to ensure that where companies aren't doing the right thing, there are ways of holding them accountable here.
Thanks, Karen. And you've touched on a few issues, again, that I hope we can circle back to in conversation. Kylie, perhaps the other side of the coin, we've already heard the United Nations Global Compact name be invoked. What is the UN Global Compact in your own words, and how does that contribute to peace and human rights within the business community?
Yeah, sure. Thanks, Jonathan. And yeah, thank you to Shelley. That I echo what Karen said. There was a lot that you said that I actually wasn't aware of. So it was a fascinating history lesson. Thank you. As Shelley mentioned, the UN Global Compact was launched in the year 2000 by the then Secretary General of the UN, Kofi Annan. And what the idea was, in addition to really prompting businesses to do more, it was a call for businesses to really integrate into their strategies and operations what we call our 10 principles. And so these include human rights, labour, environment, and then about a year later, anti-corruption was added to that. And the idea is that they act responsibly according to those 10 principles, but then also take action that advances basically societal benefits. And these days we use the Sustainable Development Goals, or the SDGs, as the guide for that. So really the best way of looking at it is a leadership platform for the development, the implementation, the disclosure and the innovation in responsible and sustainable corporate policies. So in Australia, we're obviously the local network of the UN Global Compact. We work very closely with businesses to deliver the ambition needed to meet sustainable development goals, and also through things such as advocating for better human rights, responses by business, same with environment and bribery and corruption. Really, from our perspective in Australia, we've focused on human rights very much since the UN, since the GCNA's inception 11 years ago. So human rights, including labour, is really central to what we do. From our perspective, corporate sustainability really starts with a company's value systems and a principle-based approach to business. So that means that companies have to operate in a way that, at a very, very minimum, they meet those fundamental responsibilities in the areas of human rights and labour, and not to harp on about the UN guiding principles on business and human rights, but we would see that as a minimum standard. Our view is that if companies incorporate the principles, and the principles 1 to 6 of the 10 cover human rights and labour, that they'll actually be able to establish this culture of integrity. They'll be able to uphold their responsibilities to people and to the planet, and really set the stage for long-term success. that doesn't come with its challenges, right? We know that institutional structures can cause difficulty with that. And we know that, you know, to Karen's point, we know that there isn't always enough done in a lot of these areas. But we also acknowledge that the impacts of things like corruption obviously also have a really big influence on things like positive peace outcomes. And so it's important for companies to understand all of those principles, not as principles within themselves, but also the connectivity between environmental abuses and human rights abuses, corruption abuses and labour, etc. In addition, we really think that the SDGs help orient businesses towards a broader social purpose. And so it enables them to embed a lot of these human rights mechanisms more broadly. I guess the challenge there is that it means that businesses don't necessarily talk about human rights in human rights language. It tends to be a bit more of a vague topic, which can then mean translating the SDGs or translating human rights into things that make it relevant for us human rights professionals can be quite difficult. So I think overall for us, people are central to everything. Respect for human rights is respect for people, regardless of age, culture, etc. And it is actually the core to fixing other intractable problems, right? You can't have peace without respecting human rights. Businesses obviously play a very significant influential role in advocating for inclusive economic growth. And I think it was both Karen and Shelley who mentioned that from a global perspective, there are a lot of countries out there that don't have the same level of income as we do here in Australia, and they don't have the institutional structures or the rule of law that we've come to expect here. And so when businesses enter jurisdictions, they probably have they do have an added responsibility to really understand what influence they are having and how they can work towards bettering human rights in those jurisdictions. And I just want to very, very quickly, sorry, Jonathan, just touch on, you know, a couple of the things that both Shelley and Karen said about, you know, keeping that debate alive around business and human rights. And I think, you know, this year marks the 10-year anniversary of the UN Guiding Principles, and there is some work being done in terms of how those principles can be strengthened. From our perspective, I would urge businesses to get more involved in that. You know, to Karen's point, there has been quite a lot of commentary around business understanding the actual application of the UNGPs, particularly when it comes to whether they're directly linked, whether they're complicit, etc. There is still a lot of misunderstanding around those different ways to be linked or contribute to a human rights abuse. And so it would be really important for businesses to get involved in that 10-year review so that we can ensure that there is a better understanding of how that mechanism works. And that's from all sectors. You know, we know from our work that the financial services sector really does struggle with that. And we've seen that struggle through cases such as the Phnom Penh sugar case with ANZ, which took quite a lot of time to get to a remedy point. You know, the binding treaty is another really interesting one that I don't think gets a lot of attention in Australia, and therefore businesses understanding what's going on in that space also doesn't get enough attention. And, you know, I agree that there is a plethora of legislation, and, you know, we'll have the opportunity next year to review the Australian Modern Slavery Act and look if the stick and carrot approach needs to be improved in that sense. I will, however, say that I think there is still a massive learning piece within the modern slavery part. We run a modern slavery community of practice. We've also just released, and I'll pop them into the chat, but we've also just released 2 publications around effective grievance mechanisms. And what we're finding is that even companies in the top end of the ASX, they're not always necessarily understanding everything going on in the human rights space or the modern slavery space. And so I think there is still a level of learning, and those companies down in that lower end of the 100 mil turnover, they're not necessarily getting the tools that they need to be able to respond and understand the risks of modern slavery in their supply chain. And that's overlaid with the fact that a lot of small to medium enterprises are being asked to guarantee that they don't have modern slavery in their supply chain when they probably don't really understand what that means. There's still a bit of confusion around the difference between, let's call it, indecent work and modern slavery. So whilst I don't disagree that there are absolutely opportunities to improve the Modern Slavery Act and incorporate things such as human rights, mandatory human rights due diligence into that legislative process, I think we've also got to be really cognizant of the learning path that a lot of companies are still on.
Thanks, Kylie. You mentioned grievance mechanism there, Kylie, just to pick up one thing.
That's a really big one in there.
I know, I think Shelley and Karen have also mentioned access to remedy as being a vital component of this push for greater business respect for human rights. And we've got a few questions already as well from the audience about remedy, grievance mechanisms, having actually just a complaints mechanism to be able to air those complaints and hear them is the first step in any effective remedy mechanism too. But we'll circle back around. We've got a long list of things to circle back around to. Phoebe, I was hoping my opening question to you, Phoebe, was perhaps to circle back around to the Modern Slavery Act as one of the key sort of measures, legal measures that have been put into place in recent years here in Australia to push for greater business respect for human rights. Could you tell us a little bit about this Modern Slavery Act that we've already had invoked a few times already, other measures that are out there, and any sort of legal issues that your clients of a major Australian law firm are sort of coming to you to seek to respond to in terms of human rights?
Yeah, sure. Thank you, Jonathan. And thank you all for starting. I've got so many things to come back to you about. And Kylie, you finished on the learning that needs to go on still in the business community, and I think that that's absolutely enormous. And when you're in the human rights community, it all seems very familiar, and some of it, despite the complexities, some of it feels quite obvious. But it's interesting to me how few people can go through business school and they don't touch on human rights. They don't know what they are. You know, you get the question, what do you mean by human rights? Which human rights are you talking about? And even with law graduates, a lot of law students will get through an entire law degree and come into their legal practice with no background in human rights. So I think the learning needs to start right from the bottom up, and the process of implementing some of these things is really difficult. So the Modern Slavery Act came into force at the beginning of 2018, and it requires businesses to report on the risks of modern slavery in their operations and their supply chains, and in the operations and supply chains of any entities or businesses that they own and control. So it's quite an extensive reporting requirement, but that's all they're required to do. So to comply with the Act, you just have to submit a report. There are mandatory reporting requirements in that. And where, Karen, I completely agree with you that the Modern Slavery Act doesn't really require businesses to do anything to meet the minimum requirements in the modern slavery reporting requirements to actually have a compliant report submitted. You actually kind of do need to do something, or at least say what you're doing, because it requires companies to assess the risks and identify the risks of modern slavery in their supply chain and to describe those risks. And that's a really hard thing to do if you haven't looked. It requires companies then to talk about what they're doing to address those risks, what actions that they're taking. And again, if you're not taking any actions, it's really evident when those reports are being written that there has not been much done. And then it requires companies to talk about the effectiveness of those actions. And I think that particular part in the Act is a little bit problematic. The guidelines that the Australian Border Force have put out, I think, are pretty good, and they're really based on those principles, those UN guiding principles, and require companies to think about how they might be either causing, contributing, or directly linked to modern slavery in their supply chains and operations. What we're seeing, though, is that people are still not really understanding what any of that means and what it looks like. And to address some of these risks, companies are trying to put in place warranties in their contracts, asking their suppliers to warrant that there's no modern slavery in their supply chain. That's an impossible task. We all have computers, mobile phones. We know that cobalt is 70% of the world's cobalt comes out of the DRC. Much of it's dug up by children. And so instantly we have modern slavery in our supply chain, and you cannot ask somebody to warrant that it doesn't exist. So there's a whole range of kind of issues around what that looks like, and how then, having identified that that might be a risk in your supply chain as a business, how can you effectively do anything about it? And I think that now that we're getting into the first and getting into the second year of modern slavery statements, so in the first year, many businesses have really focused on their governance processes and mechanisms, and looking at their policies and their practices and what their contractual requirements and standard form contracts might look like, and how they can try to look at their supply chain and assess those risks. But where those risks don't lie, maybe in their first or second tier, which is a little bit contractually closer, and you can require things, it becomes really difficult for people and for businesses to understand how they can engage further down the supply chain. And that, you know, that's something we can come back to in terms of thinking about what remedy looks like that far down the supply chain, and even how you provide access to grievance, how you provide far enough down the supply chain access for people to complain and to report issues. I think just a couple of other developments which I think are really interesting going forwards, looking at what's coming down the chain. And one is mandatory human rights due diligence. It's in January this year, the European Union's Parliament's Legal Affairs Committee approved a report recommending a legally binding human rights due diligence obligation for European Union companies. What this does is it shifts it from that voluntary guideline space into a mandatory requirement to have some form of due diligence in place, and looking at what that might look like. And some of that might be around a kind of a failure to prevent, and the Australian Law Reform Commission, looking at corporate responsibilities, raised the spectre of having or bringing into play in Australia a failure to prevent offence, which would require businesses to be able to demonstrate that they had systems and processes in place to try to prevent these sorts of things, similar to what is in place for foreign bribery offences in different parts of the world. So there are really interesting ways of compelling companies to think about these things coming down the track. And I think that companies who are interested in being on the front foot need to be thinking about a much broader array of human rights due diligence than just under the Modern Slavery Act. I think I'll leave it there and let you have a conversation. I've got a few other things to talk about.
No worries, Phoebe. Thank you. And I notice time is quickly running away from us, but well, let's go to the accountability question. Kylie mentioned already carrot versus stick approach. Which one is more appropriate? We've spoken about the Modern Slavery Act as being purely disclosure based. There's no enforcement, there's no penalties, there's no follow-up action required. So are there other accountability mechanisms out there for human rights abuses, and what should there be? We've had a few questions in the Q&A one I think summed it up really quite nicely. We need huge remedies. There is a saying, do it, then ask for an apology later. That is, destroy it. And then what are the consequences? Virtually none. So maybe we can just quickly run around. Shelley, we'll start with you again. What should accountability look like, and are there any bright spots?
Oh, gosh, that's a hard question. Well, I mean, there's a kind of another aspect to this, which is, you know, how do we understand what a company's level of responsibility is, as a kind of way to think about this. And then the thing I'm really interested in is not just how do we understand the nature of their responsibility and therefore what kind of accountability should flow from that, but also like what kind of business structures are they in, and how bad are the human rights violations? So, you know, I think they're things to put in the mix. Although a human rights diligence or due vigilance model in Europe, which has penalties attached to it, is what is kind of seems to be kind of favoured at the moment. I don't think it's appropriate for all situations, and partly that's because of the structures of supply chains and so forth. And I think that sometimes measures that are linked to trade preferences and to for example, the US hot goods legislation, which actually puts a ban on goods which are produced with child labour or forced labour, that can be more effective than going through this kind of trying to make somebody at the top of a supply chain responsible for all the reasons that Phoebe outlined. But, you know, I think there's ways of dealing with this in jurisprudence, which Karen would be really, really familiar with from the area of torts. Jonathan?
And I wanted to pick up on that. Karen, should we hold directors individually accountable rather than companies? Should we hold the boards and the individual people in the leadership accountable?
Yeah, in certain circumstances, definitely. I think there's a range of measures, as Shelley was saying, that are needed. There's no one size fits all or silver bullet as far as these things go, and you do need a range of different types of legislation, both civil and criminal, to deal with the different types of situations that may arise and different levels of responsibility and complicity that companies may have. But I think that the common thread that runs through all of the effective things is that they're enforceable, and that we need to move beyond this kind of talk of voluntary measures and the journey that taking companies on a journey towards a slightly more prescriptive approach to dealing with these issues. I mean, I'm kind of surprised, just to be a little bit provocative. While I acknowledge that companies might need assistance in starting to map their own supply chains and things, it's how you encourage them to go on that journey. And I think that you'll find that companies, we've seen in the modern foreign bribery space, for example, the potential for a bill which imposes a failure to prevent offence in relation to foreign bribery has seen companies very, very quickly trying to get up to speed on those issues and make sure that they do know what's going on in their operations and supply chains. And forced labour, like foreign bribery, like financing of terrorism, it's already a very serious crime that is already criminalised under Australia's Commonwealth criminal laws. Why is it then that we treat that so differently and say that, companies need sort of 5 years to just be sort of reporting on their approach when we don't take that approach with other serious crimes?
Thanks, Karen. We had a question also, and Kylie, I was going to direct this to you. Without a regulatory body, how can we know whether business reporting under the Modern Slavery Act is honest? The Global Compact has that same sort of theory of change in terms of each of your members has to report regularly about upholding your principles.
Yeah.
Do you think that can actually create the change that we want to see?
Yeah, look, I think the regulatory body question is an interesting one. I will note that the business engagement unit within Australian Border Force does actually, surprisingly, review almost every single submission that comes in under the, or report, I should say, that comes in under the Act. We're in regular contact with them. They have regular feedback around what companies are and aren't reporting against, and they do go back to companies if the reports are not at the standard expected per the guidelines in the Act. In terms of, the regulatory versus, I guess, mandatory reporting but not regulated, so similar to the UN Global Compact, yes, we require companies to report annually on their progress against the 10 principles and how they're contributing to the Sustainable Development Goals. That's called a communication on progress. I definitely can't say that we review every single one of our members' ones. I definitely try to read them or scan them at the best. But, we're a small team. I can't review 150 to 160 communications on progress. Having said that, the UN Global Compact has realised that just a reporting mechanism is often not enough to understand how well companies are progressing against the 10 principles. So this year, it's as part of our new global strategy, we are actually changing the communication on progress, and that's going through a review process at the moment. That will probably lead to there being more uniformity in the UN Global Compact's expectations of how companies report, and possibly through a questionnaire that allows the UN Global Compact and all of the local networks to gauge how well a company is progressing. And there will be a stick to that. So it was announced as part of the global strategy that companies that don't show progress or don't have a valid reason for showing progress year on year will either end up being what we call expelled or disqualified from the UN Global Compact, or they'll be listed as non-communicating until they work out that progress. So the details of that, and I'm conscious that I've probably got a couple of UN Global Compact members on the call, and Phoebe being one of them, Phoebe's company being one of them. That approach hasn't been set in stone yet, and it's still going through quite a lot of internal consultation. But I anticipate in the next few months it'll go out for consultation to our members, because again, the regulatory versus, how much benefit are you getting out of it, the balance hasn't gotten right yet.
Yeah. Phoebe, if you were not the head of business and human rights for a law firm, but the Minister for Business and Human Rights in the Australian government, we've done the Modern Slavery Act. What's next on your agenda?
Well, I think if I was the Minister for Business and Human Rights, I think I would be looking at enforcement mechanisms, because I think they're really important, but not only enforcement mechanisms, but also the will to enforce. So we do have some mechanisms to hold, for example, executives criminally liable for things, particularly where they relate to armed conflict. So companies, and I'm slightly diverting from your question, Jonathan, so I hope you'll forgive me, but companies working in situations proximate to conflict, and we've touched on these around, Cobalt, the countries that you mentioned at the beginning of the year have got particular responsibilities and particular risks under a whole nother legal regime, under international humanitarian law, which is a particular legal regime which applies as soon as a threshold of armed conflict applies. But also in those situations, things like modern slavery could reach a threshold of an international crime, so either a war crime in the context of armed conflict, or a crime against humanity, which doesn't need to be in a context of armed conflict. So suddenly, if you reach those thresholds and those international crimes, they're justiciable in Australia, but also at the International Criminal Court. in 2018, there were 8 executives of a French company were charged with financing terrorism and endangering staff, and the company was charged with complicity in crimes against humanity, as it was found that payments were made to an extremist group in Syria to keep their operations going. So there are mechanisms available, but they're not very well enforced, and it's very difficult, obviously, to enforce these things when the operations and the crimes and some of these human rights violations are international, the gravest of international crimes are taking place. For companies who are interested in that, the Red Cross with RMIT have put together a really great publication looking at specifically everything that businesses need to know about international humanitarian law and their operations in those areas. And it's an particularly interesting area because there are protections and also risks for companies under that legal regime. So important for people to be aware of it.
Thanks, Phoebe. All some great information. We did have a question. We have run out of time, but maybe Shelley, Kylie, 30 seconds to each of you. Does Rotary and do the audience members have a role to advance respect for human rights amongst businesses? 30 seconds. Kylie, then Shelley.
Yeah, absolutely. Like, you know, consumer purchasing power has a massive impact on this. So, you know, it's all well and good to be critical of businesses, but also it has to follow through from the consumer level. So if you know of a company that's contributing to modern slavery or contributing to areas of armed conflict, you've got to be a conscientious purchaser as well. And Rotary and its members can have a role in that as well.
Shelley?
Yeah, agreed. Rotary has so much moral influence. I think it has such a big role to play here, especially because, and this is, all of us will agree, I'm sure, and Jonathan especially in his work on conflict, that where human rights are being undermined, this often leads to conflict because there are often winners and losers, and that creates a situation of opposition and conflict. So I think this is something that Rotary should be taking a huge amount of interest in and asking maybe, why are we looking at modern slavery in particular rather than a full range of human rights? And I think that's a kind of a big place that Rotary could take this.
Fantastic place to end human rights. There's a whole panoply of human rights that we can speak about. Unfortunately, time has gotten away. That was 1 hour. We could have spent many, many more hours talking about it. Thank you so much to each of you and to Karen, who had to jump off early. I hope that's been enlightening for everyone out there in the Zoom world, and I know it has been for me. Human rights are universal, and if we are ever to secure our human rights, we need all societal actors, all stakeholders, governments, individuals and businesses to respect and protect human rights. And in that way, make the world a more peaceful place. So there's work for all of us to do. Thank you all for coming along. And I now encourage you to join the final plenary session of this Rotary Future of Peace Leadership Symposium, discussing how do we reverse the doomsday clock.